Now for a little bit about today's presenter, Michael Greene. Michael is an associate attorney in Fisher & Phillips Columbia office and has practiced management side labor and employment law throughout his career. As a member of the Affirmative Action and Federal Contract Compliance Practice Group, Michael advises contractors and subcontractors on developing, maintaining, and analyzing their annual AAPs, as well as the other obligations associated with federal contract work. In addition to preparing AAPs, he has successfully guided contractors through OFCCP audits of their affirmative action plans. In addition to federal contractor work, Michael has appeared before state and federal courts and agencies to defend employers in a variety of employment-related disputes, ranging from discrimination to wage and hour. Through proactive conversations and management training, Michael works with clients to identify and address potential legal exposure in the company's workforce. Michael routinely speaks at HR and legal seminars about new laws and regulations, emerging employment trends, and best practices for human resources professionals. In 2016, Super Lawyers magazine recognized Michael as a 2016 Rising Star, a designation awarded to less than 2.5% of the practicing attorneys in the state. He is also an active member of the South Carolina and the Charlotte area industry liaison groups. During law school, Michael served as chair of the Honor Council and editor for the Southeastern Environmental Law Journal and received the Joseph O. Rogers Jr. Scholarship. Prior to graduating, he clerked for the Honorable Henry F. Floyd, who now sits on the United States Fourth Circuit Court of Appeals. So we have a very well credentialed speaker today who knows a lot about the OFCCP, and we're very happy to have him. So thanks all for coming out, and thank you, Michael, for coming on today and helping us out. I'm just going to go ahead and turn it over to you if you can hear me.
Thank you, Eric. I really appreciate that, and thank you for the introduction. Just to give you a little bit more about the firm, as you can see, we have 32 offices nationwide with approximately 360 attorneys. While we're going to talk about affirmative action plans in the OFCCP today, we handle a wide variety of matters, which I'm not going to read off for you. And while we're talking about it, Eric had mentioned that I'm an active member of the SCILG and the CALG, or the CALG. And as it relates to affirmative action work and federal contractorship, the National Industry Liaison Group will have its annual conference August 2nd through 5th in Charlotte, North Carolina this year. And it's another good resource if you're just now getting into federal contractor work. Then I highly recommend you look into it. I'll be speaking there on emerging compliance leaders, which I think is appropriate for this topic of conversation. Is what we're going to do is we're going to talk today. We're really going to talk today about the basics of OFCCP. How to determine if you're a contractor, and then go through the various types of obligations you'll have as a federal contractor, or subcontractor for that matter. And this is a good place to go ahead and say that whether you're a contractor or subcontractor, you're going to be subject to the same obligations so long as you hit certain thresholds. And that's going to be really important. So anytime I talk about a contractor today, just know I'm including subcontractors in that group as well. So let's kind of start with a look back at the OFCCP's history to some degree. In 2010, Director Patricia Hsu was named director, and prior to her being named director, the OFCCP had somewhat of a reputation as doing its job, doing investigations, but contractors didn't necessarily take the audits very seriously. And when Director Hsu was put into her position, she addressed the contractor community and said, we're going to be extremely proactive and aggressive. The message is it's a new day at the Department of Labor and it's a new day at the OFCCP. And she came in from the get-go and actually called herself the new sheriff in town and said that that she was coming in to enforce the laws and the regulations. And sure enough, over the past 6 years, this is exactly what we've seen under her administration. The OFCCP has more change in the last couple years than they've had in probably the last maybe 10 years. They've been very proactive in writing new directives, writing new regulations. As I'm sure you've heard about the executive orders President Obama has signed, that they've worked very closely to pass these or to have the executive orders signed, and then for the OFCCP to write the regulations that will enforce the executive orders. A little bit more about Patricia Shu is that she does have a plaintiff's attorney background, and she ran a legal clinic in San Francisco for a number of years. So that is who is in charge of the Office of Federal Contract Compliance, is maybe where I should have started. But on that note, let's look at some of the acronyms that I may be using today, or that come up throughout talking about the OFCCP. And I'll also say, this is going to be a brief overview, sort of a buffet where you're going to get a little sample of a lot of different areas of the OFCCP's jurisdiction. Even if that's the case, I think for those of you that are more seasoned professionals in this area, with the amount of change going on, I'm pretty sure you will still hear something new that you'll be able to take away. But let's look at the acronyms. OFCCP is the Office of Federal Contract Compliance Programs. AAP is Affirmative Action Planner Program, depends on who you talk to, what they might say. IWD is an individual with a disability. Section 503 is the portion of the regulations dealing with individuals with disabilities. VEVRA deals with our veterans. LGBT is lesbian, gay, bisexual, transsexual, or transgender. Occasionally you'll hear LGBTQA. This is an evolving term that you'll want to keep up with. And then probably the most confusing of them is the EO, EOE, EEO. People have a number of different ways that they abbreviate equal employment opportunity or equal employment employer, however you look at it. And then to make it even more confusing, we also have EOs, which are the executive orders, and you'll hear me refer to EO 11246 a number of times today. So we're going to start pretty broad, and then I'm going to kind of narrow down. So a little of this will be repetitive, but if you're new to this or relatively new to this area, then the repetition should help you get a better grasp of what we're talking about. So who's covered? What we're talking about is private employers who have contracts with the federal government. And if you have a direct contract, you're described as a prime contractor, which means you are contracting directly with the federal government. And we're also going to be talking about federal subcontractors, which I briefly mentioned. And a federal subcontractor is a subcontractor who contracts with the prime contractor for goods or services necessary to the performance of the federal contract. Now, we can spend a lot of time talking about the ins and outs or the details of this, but by way of an example, it's very fact dependent whether a subcontractor is going to be a federal subcontractor. For example, you may be, say, a snack supplier, and if you're supplying snacks to maybe a manufacturing company that makes a widget for the federal government, say it's something that goes on a tank, chances are that snack that you're supplying for the vending machine isn't exactly necessary to the process of the manufacturer building a tank. Let's change that a little bit. Say, however, as a snack provider, you're providing snacks to a company that runs the commissary or runs a restaurant in a federal building or on a federal, at maybe an army base or something. Now providing that snack is more essential to the ability to provide food services than, say, it was to providing a manufacturer for their vending machines. So you really have to break down and look at what you're providing as a subcontractor to determine whether you are, in fact, a federal subcontractor. By way of that example, the snack provider could be in one situation and not in the other, but because they would be a federal contractor in at least one situation, then they're going to be covered as a federal subcontractor. This is also important from the contractor's perspective because they need to know who their subcontractors are, as we'll discuss in a few slides. Probably towards the end of this presentation, we'll discuss how some pending regulations may affect the contractor's duties regarding a subcontractor. One other note on the subcontractors is that a subcontractor, that trickles all the way down. The way the regulations are written, there is no first tier, second tier, third tier. We do identify a first tier subcontractor in some cases, but even a third or fourth tier subcontractor could still be potentially liable, is still potentially liable for following all the obligations that OFCCP promulgates. Let's talk about some things, and we're going to talk about the thresholds that you have to meet certain AAP obligations. But typically speaking, grants from the federal government are not going to make you a federal contractor. So as we work through this, we have what we call, and I'd use the air quotes, full affirmative action requirements. So what does this mean? And as we'll see in a slide or two, there are different levels of obligations, but the full affirmative requirements are going to generally be no discrimination of certain categories, required contract clauses, filing certain reports. The EEO1 and the VETS 4212 specifically, these are reports that look at the demographics of your workforce, and the EEO1 is actually something you're supposed to be filing on a yearly basis if you have over 100 employees. It gets wrapped in if you have less than 100 employees but are a federal contractor, and these are due at the end of September each year, and again, as I said, are required. And then also written affirmative action plans, which include statistical analyses. So I'm going to talk very briefly about construction contractors. As you can see, there are the thresholds on the screen, and these contractors have slightly different obligations. Those 16 specifications there under the second bullet point. And I'm not going to go through those today because they are different enough from what we're going to talk about mainly, which is supply and service contractors. But just be aware that if you do offer construction contracts that, or you're a construction contractor, that you're going to have slightly different obligations than what we're discussing here today. It's also something that you should note is that for a couple years now they've been discussing whether they're going to change these 16 specifications. So if you're a construction contractor, be on the lookout for those changes. All right, so there's three main places we get our information from. That's EO 11246, Section 503 of the Rehabilitation Act, and VEVRA. So EO 11246, in a nutshell, this covers minorities and females and is covered in the regulations under Part 60, which is also another shorthand you might hear. And as I was discussing before, you have a basic coverage that starts at $10,000, a $10,000 contract in the year, and then any number of employees. And these employees, and this is basically that you have a non-discrimination clause or policy for minorities and females, and then also that you have certain postings. The full coverage is really what the interesting thing is to talk about. That's what the meat of our obligations come from, and that's when you have a $50,000 contract and 50 or more employees. And those thresholds are fairly low. I mean, most contractors are going to be covered by these clauses, by these obligations. So what do I mean when I say a full? Well, the written AAP for each establishment with 50 or more employees. So each affirmative action plan is going to be for a single year, and this written part of it's a narrative. It talks about the policies the company has. It talks about what you do with your outreach. It talks about the company itself and its structure and organization, and how it goes about in making sure it's meeting its obligations. This part is one of those things that you get set up once and then you maintain and tweak over the years to make sure that you're staying consistent with, one, the changing obligations and regulations, but two, to also make sure you're you're in compliance with or keeping up with trends and how people are being referred to and things like that. So that's the first part, and it's a major part, but it's probably the least work intensive. It's all the following parts, following bullet points where you really have a lot of work to do. So you have to break down your workforce by job groups and departments, and there's different ways that this can be done, and the regulations are very specific about who can go where and how it needs to be done. And this basically gives you a snapshot of your workforce. You have to analyze your applicants, hires, terminations, promotions, and transfers. What the OFCCP is concerned with, and the Executive Order 11246 when it was signed, is tracking to make sure that these groups are not being discriminated against consciously or unconsciously in the workplace. And so in order to do that, the OFCCP wants you tracking all of these different employment actions so you can see what's happening. You can see how people are moving through the company. Compensation analysis, again, another part of this is, while it doesn't do much good to make sure you're hiring people in a non-discriminatory way if you're not paying them in a non-discriminatory way. Now, compensation we'll talk about right at the end of the presentation, but what's important to understand here, excuse me, is making sure comparing your workforce to make sure people in substantively similar positions are being paid the same. And if you do find that you have issues with underutilization of a certain demographic, that you're taking measures to change that. What are you doing with your outreach? And this is a lot of work, and you can see this, and that's why once you enter a federal contract, you have 120 days to put your affirmative action plan in place. And so you do have a little bit of a grace period, but as you can see, if you're going from 0 to 60, this is a lot of work to be done in even a 120-day period. One thing that I recommend if you are looking to start your affirmative action plan is try to set the date outside or away from maybe one of your busier periods. For example, if you have open enrollment periods for HR or end of the year things, try to stay away from that when your workforce, your HR people are going to be really particularly busy. Now, another question we get, and I've focused on these types of supply and service contracts because they form the majority of people or contractors. What we also have, another two ways you could be wrapped into this is also if you're a federal depository, which is a slightly longer way of saying banks. And that's if you're a federal depository in any amount, then you would be covered by this. And then if you have bills of lading, some employers or companies, they do storage. So if you have bills of lading in the amounts above, then you would also be covered as a federal contractor. So let's move on to VEVRA. And VEVRA's the regulations that oversee veteran discrimination or prevent veteran discrimination. What's important about this is it recently changed in the last couple years. There were a couple different ways that they looked at these categories, but the new 4 categories are there on the screen for you. What's important to understand is these are the only 4 protected under VEVRA. That's not to say that other laws, state laws, protect other types of veterans, or possibly USERRA, which just about every employer is subject to. So there may be other laws that are broader, and I should say this too, for anything we discussed today, there may be other state or federal laws that require you to do something in addition to these. This is strictly under the OFCCP's jurisdiction. Basic coverage for this kicks in at $150,000, and then again, the full coverage kicks in when you have 50 employees or more. And what this requires is not quite as much work as the EO 11246, but what you'll look at is your applicants, hires, promotion data. I'll talk about this in a little bit more detail later, but tracking that for the workforce in whole. So Section 503 deals with IWDs, and the threshold for these are a little bit lower. $15,000 contract with any employees for the basic. Again, that's the non-discrimination clauses, postings. And then the full coverage, This sits somewhere between your EO 11246 and your VEVRA requirements, in that you do a little bit more analysis, statistical analysis of your workforce. You break out your statistical analysis by job groups, whereas VEVRA is just for the workforce in that establishment. And then this also harmonizes with the Americans with Disabilities Act, which is really important because they do go hand in hand. The ADA was amended in the early 2000s, and then this came out in 2014 to say we're catching up with this. We want to track this. We're going to look into this. So there's a few other places that federal contractors look to find out what their obligations are. These are a number of executive orders that have been passed in the prior years. One is the right to organize, which is most employers do not particularly care for, that they have to tell their workforces, hey, you can join a union. Some employers will post a side-by-side posting that says you also have a right not to join a union. I suggest that if you're going to do a counter posting, you discuss with your labor counsel. It's certainly something we can help you with if you have any questions about that. The pay transparency, this is a really big one, and it came out and it basically protects employees' rights up and down the management chain as well to discuss their pay. And I'll talk about this a little bit more at the end and how this is different from the NLRA's requirements. One of the big executive orders that's been passed, and that's 13672 with sexual orientation and gender identity, is getting a lot of attention right now, particularly with North Carolina's HB2 law. Federal contractors have an obligation not to discriminate based on sexual orientation and gender identity. That's essentially the end of that one. It's a very short executive order that President Obama signed last year. We have two pending executive orders that at this point do not have any obligations attached to them, but we're watching very closely to see what they may be. One is the Fair Pay and Safe Workplaces Act, or excuse me, just Fair Pay and Safe Workplaces regulations. And this is one that's going to make bidding for contracts a little more competitive, in that contractors who are found in violation of 14 different categorical types of employment laws will have to report these. And if the pending rules end up the way they've been written, the rules that were put out for comment, then contractors will also have to report any issues that their subcontractors have. And this kind of goes back to a couple slides ago where I said this could be important for you to know in the future who your subcontractors are and whether they're violating employment laws. The last one is the paid sick leave, and this is one that we are fairly confident will come down in possibly the next couple weeks, but certainly before September 1st. President Obama was very clear he wanted a final rule before September 1st. And this, all we know at this point is that federal contractors will have to provide 56 hours of paid leave to their employees, presumably working on federal contract work. Now, we're not entirely sure what exactly that's going to entail yet. The pending rules, or the rules that were put out for comment and notice and comment, are a bit convoluted, very, very dense. And I can tell you from reading them, it looks to encourage employees just to give 56 hours of paid leave. Where this is really going to be interesting is a lot of employers have moved to a PTO system where they just put sick leave and vacation leave together, as opposed to having them separated out. And we're not entirely sure how that's going to work yet until the final rule is published. So a couple other sources for you. Directive 307 is the new compensation analysis. This was, I believe, released in 2013, which the OFCCP used to look at compensation one way, basically W-2 forms. Now they've said that they're going to take a Title VII approach and they're going to do a case-by-case analysis. So any facts, information, evidence they think that they need to look at to compare whether compensation is being fairly assigned, they're going to look at that, and they have that right to do it. The Federal Contract Compliance Manual is the manual that compliance officers use when performing an audit. So sometimes that gives insight into how they're going to approach an audit. It can help you better structure your affirmative action plan. And the last one, and I think what's probably pretty important about this, is the OFCCP's website is a great resource for any sorts of FAQs you might have. They have actually mandatory postings as well as handbook language on there, as well as, and you'll see this shortly, the Section 503 self-identification form. So it's a really good website, as is to some degree the EEOC's website. And I bring the EEOC up because the OFCCP and EEOC have recently exchanged letters saying that they're sister agencies and they're going to work together to root out discrimination. They have been very clear about this. This is not something that the contractor community has kind of figured out by putting pieces together. This was very blatant that if they see issues in an audit or in an EEOC charge, that they're going to share information with each other and say, you know, you might need to look into this. It's outside of my jurisdiction, but it's something you might be interested in. And then also you see the class member locator website. If you've not gone through an audit, then you may not be aware of conciliation agreements. And conciliation agreements are the way in which, if any violations of the regulations are found, that's how a contractor resolves the issue. And a conciliation agreement can involve a number of different things, and we'll talk about this at the end of the presentation. But most importantly, it can involve monetary penalties, such as back pay. And what the OFCCP is doing now is putting these conciliation agreements and the contractor's name on their website and saying, you know, in this demographic at contractor XYZ, guess what? You may be entitled to money. Come look at our class member locator website and see if there's something that you can recuperate. All right, so let's talk a little bit more about the affirmative action plan itself, now that we know how to figure out if we're covered by one. So I discussed the written plan a little bit earlier, and we've discussed that it covers 1 year, so whatever that anniversary date is, you know, say January 1, 2016, then it covers for that year. What's important to understand too is that to do your statistical analyses for the 2016 year, you'll have to look back to your 2015 affirmative action plan year. If you've just now started, obviously you're not able to look back, but you just start that trend moving forward. For each establishment, there's different ways to determine who's in which establishment. Obviously, one way would be physical locations, but that's not always the case, and there's very specific rules about who is reported in which establishment. Typically, people follow their managers, and they'll be at that establishment. So, for example, you may have someone working in your Columbia, South Carolina office, but they report to someone in their Charlotte, North Carolina office, and they may not be, and they may be reported. The Columbia person may be reported in a different affirmative action plan than would be maybe the obvious choice. And you see there I have the FAAP, which stands for Functional Affirmative Action Plan. The OFCCP just released new directives on this, and I've not had a chance to thoroughly look through them yet because they came out, I think it was Tuesday. But this is an idea that sometimes businesses aren't structured, companies aren't structured exactly like the regulations would think that they are. So this is another way to do it. Traditionally and historically, this invites a lot of auditing from the OFCCP, because in order to qualify for it, you have to apply to the OFCCP and you have to go through an audit every couple years to continue to maintain the FAAP. Some companies find that this is very helpful for them. Others feel that this is not something that's worth it for them. It's one of those things that we don't often recommend this because of the structure and the invasiveness of OFCCP reaching into your audits every year or every couple years. But again, because it's an opportunity and we're doing a broad overview here, I wanted to make sure you were aware that that is an opportunity that your company may want to look into. So to reiterate again, 11246 again is specifically with minority and females, and then again as amended, by the LGBT executive order, that there's just no discrimination against them. And what we're looking to do is we're looking at the employment actions taken and then looking for underutilization of someone in those areas. So how do we figure out if someone's underutilized? We've got to get some information, some data. This is probably one of the biggest areas that we get questions about is how do we do this? So you're required to ask at pre and post offer stages. So pre-offer, you need to be asking for race and ethnicity through the EEO1 categories, which would correspond with your EEO1 report, asking for sex, veteran status, and disability. Now let me take a second to talk about the veteran status. The OFCCP has on their website a document that you can use for this. It's not the best in the world. It's a little bit confusing, but it gives you an idea. What's important to remember here, though, is that when you're asking about the veteran status, you're asking yes or no. And you lay out the 4 different protected categories and definitions for them, which can be found in the regulations or various FAQs on the OFCCP website, or I can help you with that as well. And then you say, do you fall into one of these? What's important with these is that it's a voluntary self-ID form. You want to make sure people understand that they do not have to provide this information. There is language that you can usually put in there, you know, we're a federal contractor, this is our obligation, we want to make sure we're hiring the best people and that we're, you know, have a diverse workforce. And you can explain why you're doing it, and that sometimes helps get a better response. But you do want to make sure that it's clear it's voluntary and not mandatory. The disability, however, OFCCP has a required form on their website, and I can't stress this enough, that you need to be using that form in the way that the OFCCP has put it on the internet. Don't change it, don't revise it, don't do anything to it. Use what they've put out there. And again, if you can't find it, send me an email and I'll be happy to either send you a link or send you a PDF copy of that for you to start using. So that's pre-offer. And this is a good time. The good time to do this is when people fill out their applications, because once someone fills out an application and then walks away, you may not be able to get this information from them again, assuming that they would voluntarily provide it. After you go through the process, and we're going to talk about the applicant process in a moment, but before someone starts their job, you need to give them a post-offer request, this time only for veteran status and disability. There are various thoughts behind this, and that's for these two particularly, that these are 2 categories that people may not want to offer up front. Race and sex is something that you can sort of usually figure out on your own, so that's not something they're necessarily going to hide. But the veteran status and disability is something that someone could conceal, and the thought process behind asking this before they start their job is to say, you know, maybe now that they've gotten the offer, they may be more willing to share this information. And again, you need to use the same disability form that you have to use at pre-offer that OFCCP has put out there. Don't forget to do this, you know, with your I-9s, things like that. It's a good time to do it. Don't ask for LGBTQA identification. It's not something that's required, so you shouldn't be asking it when you're doing it. And another question I get from a lot of HR people, and this is probably one of my favorite parts of presenting this particular slide, is anyone that's been in HR for a while knows that particularly disabilities is a no-no. You just don't ask that in an interview. So the question comes up, well, then how can I ask it now? Isn't that a violation of the ADA? And in fact, that was the outcry that came out when the regulations changed in 2014, and the EEOC quickly responded with a letter saying, no, it's okay, we understand why you're doing this. If you're doing it for the federal contractor purpose, that's not going to be considered a violation of the ADA. So a little more on the voluntary self-identification. We talked about the forms. You need to keep these forms, this information, separate. That's key. Keep it away from your decision makers. Otherwise, you could be inviting an issue. You could be inviting a discrimination lawsuit of some sort. There is a question as to whether an employer may identify an employee as disabled. The disability is obvious. Possibly, you know, there are some more obvious disabilities that you might say, okay, we're going to do this even if they decline to voluntarily identify. That's not typically something I would recommend. If someone asks for a reasonable accommodation, if they say, I have a disability, I need a reasonable accommodation, in that case, you can probably mark them down. And the reason why is there is no penalty outright for not having for not hitting your goal of hiring IWDs. So there's no reason to have to increase that number. And the big thing is just do not guess. If any part of it is a guess, then you should not be identifying anyone as an IWD. So I was talking about the application process, and this is probably one of the biggest areas we get questions about, because if no other reason, it's one of the most complicated areas. So let's talk about the 4 parts, and then I'll break it down a little bit more. So there's 4 parts to the hiring. There must be an expression of interest received electronically to a specific position. People can't just send in, hey, I want to work for your company. They need to be responding to something that's specific, a specific position. And you need to consider them for that position. So a lot of people have employees, you collect these online, but you never look at them, or you only look at a percentage of them. You've not considered them at that point. But once you've looked at a candidate's materials and considered whether they meet the basic qualifications, moving into number 3, you now need to retain that material regardless of whether they're basically qualified and regardless of whether they actually become an employee. And the reason why is as the OFCCP has become more aggressive in their audits, they're looking much, much closer at how people are making their decision on applicants. And even an applicant that you decide is not basically qualified, the OFCCP has said in some of the audits I've worked on, prove it. Show me their information that you considered them and you considered that they were not basically qualified. This is another good point. If you've been or listened to any attorneys talk about HR stuff, document is just critical, and this is it. And this is another good example where if you don't retain it, you've probably lost it forever. And then the last one is there's no indication of withdrawal. This means that they don't call you up and say, I appreciate the opportunity, but I'm going to take another position. It could be that you're hiring for 3rd shift and they say they're only going to do 1st shift. In that case, they may have withdrawn themselves from the process. So let's talk a little bit more about the basic qualifications. Basic qualifications and job descriptions are not the same thing. Basic qualifications sounds pretty self-explanatory in that this is the minimum level of qualification for the job that someone must have, where job descriptions may be a little bit broader. They may describe different aspects of the job, different things that people might have to do. Basic qualifications under the regulations have 6 requirements. I break them into 3 parts. One is the logistics part of it. You have to have your basic qualifications established in advance. You can't open a requisition for a job and then see who applies and then determine what the basic qualifications are. They have to be established in advance and in writing. And then, of course, you have to post them. Substantively, it needs to be objective. So an example of this is you say someone with a 4-year degree in finance or a 4-year degree in electrical engineering, as opposed to someone with a degree from a really good school. That's not an objective. That last example is not objective. That's just someone believing that a school is better than others. Non-comparative. It can't be best of the bunch. For example, you can't say, one of the top 5 most experienced candidates. That doesn't work. You need to say, if it's 5 years experience, someone with at least 5 years of experience. And then again, it needs to be relevant to the job, and that one's pretty self-explanatory. And you need to have a reason for why it's part of the basic qualification. So a good example might be if you're hiring for a custodian who, that's a position most people could probably describe to you what a custodian's going to do. But let's say a basic qualification is they need to climb a ladder. Well, then you need that in there so that people are aware of what they're applying for. All right, so let's go now to VEVR and talk a little bit more in depth about that. Again, you can see some of the thresholds again, and I don't know that I mentioned this earlier, but the Vietnam vets, they're a shrinking group of people in the workplace. So these were revised to be a little broader and protect other veterans, such as the Gulf War or veterans that have served in Iraq or Iran in the Middle East now. Let's see. And again, we talked about the pre-offer and the post-offer and why we're going to do these and when we're going to do them. And you're going to use this to assess the outreach and recruitment. And so let's go into what exactly you're going to be doing with that. So as I described, you're going to be collecting the number of veteran applicants, and then you're going to compare that to the number of hires, the number of job openings, and the number of jobs filled. Now, I'll mention number of jobs filled also includes promotions. Now, even though you're not required to survey your workforce, your current workforce, the idea is that after these regulations have been in place for a few years, that will eventually trickle into your workforce and you'll be able to track people throughout. You can see what you're going to track, and this is, again, it's really important that you're keeping track of who is a veteran, where they're going in your company, so that you can run these analyses every year because an annual assessment is required. Now, the benchmark is currently 7%, and this has actually changed a couple times since 2014. I believe it was maybe 7.2 or so, and it's come down a little bit. So what's a benchmark? Well, it's not a quota. A quota, to some degree, is going out and saying, I'm going to meet this number. I'm going to hire X number. And that's not the idea. The idea is just to be aware of the veteran population and aware of your outreach efforts. And the whole idea is that if in your recruiting efforts you're not seeing any qualified veterans applying, that it should raise a question mark for the company to go back and say, okay, what can we do better? How can we do a better outreach? Who are we missing? What's available? And there are a lot of veteran organizations, employment organizations that are out there to help veterans find employment and match them with employers who are looking for veterans. And again, there's no violation or penalty simply for failing to meet the benchmark. Violations or penalties can fall in later if the company continues, for example, to say no veterans are applying. If that's the case over year after year, then if you're not changing what you're doing for the outreach, then that's where the OFCCP might start looking for a violation. Say, okay, well, you've been on notice now for 3 years. You're not hiring veterans or not even getting applications. Why is this? What have you been doing? So again, this is another place you need to document without question. Make sure you're documenting all these outreach efforts so that you can prove what you're doing. Say, you know, in year 1, we didn't have anyone, so we went to a new organization in year 2, and they helped, and they've been working, so we're using them for year 3. Whatever the case may be, just make sure you're documenting what you're doing. You need to retain your records for 3 years. And here's a big one. Training is mandatory for managers and decision makers about veterans. Again, there's a lot of outreach groups that will help you with this. I know a ton of nonprofits really want to get out, typically vets themselves, that want to educate employers on what our veterans have done while they've served our country, the struggles that they're working through when they come back. And this training is mandatory. There's not a key or necessarily a key requirement, but that you need to be having this mandatory training each year. And of course, you can go beyond that. All of these regulations are a floor, and you can go beyond any of them and do more outreach than is required, of course. Again, assess the effectiveness of your outreach. That's, again, the biggest part of VEVRA, is assessing your effectiveness. This is one, too, that you need to be posting with your job services agency, and that's what the regulation actually calls it. Most often this is your unemployment services, in South Carolina we call it the Unemployment Workforce, Department of Employment and Workforce, DEW. And we can send to them postings, and this is required for nearly all jobs except for your very, very top executive level jobs. And again, this is an area you need to make sure you're documenting your outreach. Many of these employment agencies do not retain the documents or do not retain the postings. So if you have to go back a year, maybe even 2 years later and say, can you send me all the documentation from my postings? Chances are they're going to say, sorry, we didn't keep copies of that. Even in the electronic age, as hard as it is to believe, most of them are not retaining these documents. So make sure you are. You also have an obligation to include an equal employment clause specifically referring to veterans within your contract and also in your postings. And I believe someone had actually asked a question about the tagline, and your taglines need to include that you're an equal employment opportunity employer, veterans if you're covered, and then disabilities or disabled if you're covered. Using just D and using just V are not acceptable. The OFCCP has put out guidance on this that is very clear that people used to do, such as like age, race, gender, just as A, R, G, or EEOARG, DV. That's no longer acceptable. You need to be spelling it out, and depending on the situation, you can do it, but it's always better to err on the conservative side and spell things out. Equal employment opportunity employer, veterans, and disability if you're covered under BEVRA and 503. Let's see, we've had a couple questions come in about the training, outreach, and record keeping required for all employers or just contractors. I guess I should go ahead and go back and say this. If you are not a federal contractor, then you should not be doing any of this, generally speaking. Now, you may be required under state contracting laws or county, local laws to do this sort of stuff. Generally speaking, this is only for federal contractors. So to the extent that should you be doing the record keeping for all employers, no. However, outside of the OFCCP context, there are a number of laws that require record keeping, so you need to check with those. One that comes to mind is the Fair Labor Standards Act, which requires 3 years of record retention for the hours worked and pay and other sorts of things like that with overtime. Our job postings to job services required for a certain number of days. You need to be posting them while they're open. If you're going to keep a position open, a rec open for 3 to 5 days or 5 days, then it needs to be posted within that time. I'm not aware of a specific number, but you certainly don't want to post it for 2 hours if you've had it open longer. So you need to work that into your job posting. I guess your job posting cycle. Make sure that you find out from your local agency how long they're posting it, or how much lead time they need to make sure that you're posting it fairly with the job services agency. So moving into, let's see, here we go. Moving into Section 503. Again, you can see this, and Patricia Hsu had said what gets measured gets done, and that's again. The idea is to measure what we're doing and for contractors to measure how their workforces reflect the population. Again, you can see I've highlighted, and I cannot harp on this enough, that you must use the OFCCP's form on their website. Just to follow up, we just got another question about whether it's okay to post with the state agencies or if you have to post other places as well. This may be more of a business comment than anything. You can post with just your unemployment agencies. However, you're probably going to want to post broader than that, particularly in that outreach. If you're looking for veterans, find a veterans organization and post with them as well. The job agencies are just one required place that you have to do it. It's not that it's the only. You can certainly post however else you want. And let me mention this too. Many employers use third-party vendors for finding employees or bringing in employees. As the contractor, you are required to make sure that they are screening appropriately as well. It is not going to, if you are audited and the excuse is, oh, well, our third-party vendors didn't know, you're going to be held liable for any issues that the OFCCP says that they have found. So make sure if you have third-party vendors, you are working with them, reviewing them. I would say even do an audit of how their practices in referring employees to you, headhunters are referring employees to you, how they do that so that you can make sure that you're in compliance. So this is a little bit different, moving back to the Section 503. This is a little bit different than VEVRA in that VEVRA, you don't have to survey your current workforce. Under Section 503, you do. You see the pre and post offer for applicants, but current employees, you have to do this within your first year of being covered by the regulations. And then you also have to do this at least once every 5 years with a reminder. Now, some employers find it's just easier to remind people and ask people, at open enrollment. Some do it every other year. Some do it every 3 years. It's what makes sense for your business, but you need to make sure that you're doing it once every 5 years and that you're keeping track of that request. And the idea behind this is that someone that is a veteran is a veteran. That's not going to change. Same thing really with sex and race. But a disability is something that can be, the result of many things. It could be a natural, birth, a disability at birth. It could also be something that someone's in an accident. So this is why there's that recurrent surveying of the workforce, so that someone who may not have previously been disabled can now report as disabled if they so wish. And again, use that form that is on the OFCCP's website. So this looks very similar to what we talked about with the veterans. You're going to look at your workforce, but in this one where the veterans are for a single establishment, you're going to compare them for that workforce in total at that one establishment. For your IWDs, you're going to break them into the job groups within that establishment. And I should say that for a lot of these regulations, if you're a smaller employer or you have less than 50 employees at a certain location, then it's possible that you may have different rules that you can follow that are less burdensome, such as maybe you have 200 employees at one location and 35 at another. The way in which you process their information may be different. This is what I'm talking about today, is the general broad scooping up most contractors at most of their establishments. All right, so moving forward, Section 503, coincidentally enough, also has a 7% goal. You might ask, what's the difference between a benchmark and a goal? And I would respond, that's a really good question. Why don't we ask what the difference between a quota is? We do know that the quotas are unlawful. We've been told that by the Supreme Court and other opinions. The goal, again, is an aspiration. It's to be employing the 7%. And you're wanting to look at qualified IWDs. Again, this does not go out and just hire individuals with disabilities. They need to be able to perform the functions of the job. And this is where job descriptions are important, so that they're performing the functions, the essential functions of the job. As I mentioned, this will apply to job groups. If you have less than 100 employees in an establishment, then you might be able to just do it to the workforce as whole. We like to point this out. The OFCCP has put a lot of burdens on employers, and while they've done that, one of the things that they did listen to in the comment section when Section 503's regulations were being revised, when they put out the notice and comment period for the proposed rules, there was going to be a 2% severely disabled goal. And the OFCCP actually withdrew that decision and just took that back. So that is one place where contractors responded and the OFCCP listened. And then accommodation logs. You must have accommodation logs for any accommodations that you provide to IWDs. This is a good practice anyway under the ADA, but it is required for federal contractors. And this is something you may have to produce if you are audited by the OFCCP. And then accommodation request. An accommodation request procedure is not required. In the original rules it was, or the original proposed rules it was, and then they backed off of this. However, as a best practice, I recommend you do this. Let people know, and it doesn't have to be particularly detailed necessarily, but letting people know that if they do need an accommodation, that there's a way for them to request it and to include that, in your handbook if you so choose to have that kind of policy. So we've talked a little bit about failing to meet the goal, and again, failing to meet your goal is not an automatic violation. What's important is that you're assessing the personnel, and just like with the veterans, that you're finding ways to reach out to these different groups and try to bring them in as employees and find ways to work with their allies and groups that promote them. So analysis and record keeping. You need to be annually assessing effectiveness. For some of these, it's a periodic assessment. But if you're going to do it, you might as well do it every year. That is what I recommend to my clients, is an annual assessment. You have to do an annual AAP anyway. You might as well go the extra couple steps and do it for all 3 affirmative action plans, if you're covered by all 3, of course. That way you make sure that you're identifying any problems before the OFCCP finds them in an audit. Again, if you're not having positive outreach, then or you're not having a response in the outreach methods, that you change them. Linkage agreements are a letter of intent, so to speak, between your company and maybe a veterans group or just an IWD group. They're not required. You can enter them if it makes sense for you, but the OFCCP does not require them. And again, retain those documents for any outreach done for 3 years. I'm looking at my time, and it looks like I've got a few minutes left, and I think I'm going to run just a little bit over for your planning. I only have about 7 or 8 slides left to go, so I'm going to try to move through them quickly, but also move through them thoroughly, so just hang with me. And for those of you that may have to go, make sure that you've got our emails, and you can always send a follow-up question if you have any questions that aren't answered right now. So postings, these postings are on the OFCCP's website. They're actually right on the home page on the bottom right-hand side. These are required postings if you're hitting the thresholds for EO 11246. The EO is the law, is basically your non-discrimination policy. As a non-discrimination, we don't discriminate. Your pay transparency non-discrimination provision, and this one, I'm going to talk about this for a second. A lot of people, when this came out, said, oh, this is nothing more than the NLRA, which says that employees who have a right to organize, essentially, can discuss the terms and conditions of their employment, which means they can discuss how much they get paid. And when the pay transparency executive order was signed, a lot of people just said, oh, this is the same thing. Well, it's not really. What's really important about this is that everyone, management included, can discuss their wage, their compensation without fear of reprisal or retaliation. And what's more so than this is it goes even a step further, saying, for example, and this is a real example that the OFCCP used in a webinar they did, is that if a custodian came across maybe a salary sheet in the paper while emptying trash bins, then he or she could talk about that without fear of being retaliated, because it's not necessarily a part of their job function. Now, there are some exceptions to who can talk about this. For example, your HR managers typically cannot talk about this, although there are exceptions to the rule. So this is something that if you're not familiar with it, you definitely need to find out more about, because it's much broader reaching than the NLRA's rules and regulations. And then employee rights under the National Labor Relations Act, we discussed this already, where we talked about you need to let post that people can be part of a union if they so wish. 2 other postings that these are not required. The availability of affirmative action plans for inspection. You do have to make the narrative part of the affirmative action plan available to your employees during regular business hours. You do not have to provide the statistics. You do not have to provide names. You don't have to provide any of that kind of stuff. But you do have to provide the narrative portion of it, and you also have to make that available to applicants if they so ask. And then your EEO policies. As we've mentioned, the OFCCP is concerned with veterans, IWDs, minorities, and females. But obviously, as an employer, you're going to have non-discrimination policies for age, genetics, maybe other types of, I forgot, LGBT is in the non-discrimination policy now for contractors. You may want to go ahead and just post your EEO policies. Why not? You've got them in a handbook. You should probably post them on a board with these other postings. Show that you are, it's that showing that you do care, that you are familiar with it, and you want people to be aware of your policies. Let me go ahead and mention too, I said that 11246 is primarily concerned with minorities and females, And one thing that we've been seeing more so in the last couple of years than further back than that is that the the OFCCP is now taking the position of, whites and males are also protected under the laws, because the regulations talk about race and gender, not necessarily specifically minorities or specifically females. And there have been instances in the last 2 years where the OFCCP has found that a group of whites or a group of males have been discriminated against and have had monetary fines associated with that. It used to be called reverse discrimination. That's sort of a misnomer, because discrimination is treating someone differently. At least in this context, it's treating someone differently based on race or gender. And so be aware of that as you're looking at AAPs. That's something I've started pointing out to my clients, is when they might have those kinds of red flags. So contract language, you're required to put this in all of your contracts. Again, kind of a best practice or a pointer is that most employers or most contractors just put this into their standard contracts, so that they don't have to decide what's going to a subcontractor and what's not. You need to be referencing specific language. Again, I can get you that language, or you can look it up on the OFCCP's website. But let me draw your attention to Section 503 down there at the bottom. You need to make sure that the language referring to IWDs is bolded. And that's very, very important that you do that. Again, you need to be informing your third party, subcontractors, labor unions, vendors, recruiters. We mentioned that earlier. Let's see. Pay transparency. So I just mentioned the difference between the NLRA and that there's a posting. You also must use the language in the handbook. And the handbook language you can find again online, or I can send it to you, and it needs to be fairly consistent with exactly what the OFCCP has put on their website. About the only thing you can really change with that is maybe putting, instead of, I think it generically says the company does X, Y, Z, you might be able to say, your company's name if that's consistent with your handbook, but otherwise it needs to be in there pretty much unchanged. Let's talk very briefly about the compensation analysis. This is, as we talked about earlier with Directive 307, where it used to just be a W-2 look at, they look at that. Now the OFCCP comes in and they say, we want to know the W-2 compensation. We also want to know what opportunities are people having for overtime. What are they making at overtime? How do you assign overtime? Who is assigned to certain sales territories? How do you decide who gets to train for management? How do you progress people through this? How is any factor that can affect compensation decided? And that's made for a much, much broader investigation, and it has resulted in, and we have seen it, you can Google it, you can go to the OFCCP's website, not only more, but higher level penalties for discrimination and compensation. Another one is the minimum wage. Minimum wage doesn't apply to all contractors. It's going to apply to contractors that have procurement contracts for construction covered by the Davis-Bacon Act, service contracts covered by the Service Contracts Act, congressional contracts, and then other contracts in connection with federal property or lands or relating to offering services for federal employees. And then there are some exceptions to this. I'm not going to go through all of them at this point because that's really almost a presentation in and of itself. But you do need to be aware of it, and it's for contracts that are entered on or after January 1st. And this also is subject to go up if it continues to go up like we've seen in the last 2 years. Somewhere between maybe 3 and 10 cents, 5 and 10 cents a year is what we're expecting. Again, if we have another recession like we recently had, it may not go up. So if you are covered, you don't have to go back and scramble to increase everyone's minimum wages necessarily. Now, this went into effect on January 1, 2015. So for those contracts, you've got to be paying people at least $10.10 an hour. For January 1, 2016, it's $10.15. It may increase over the next couple years. All right, I got just a couple more slides left, and I think these are the ones you're really going to want to pay attention to. So why do you do all this? Why are you watching this webinar? Why are you thinking about all of this? And the reason's going to be pretty simple in a second, but let's talk about history again for one moment. Historically, the OFCCP, before Patricia Hsu came in, I don't want to say they went through the motions, but their investigations were not as aggressive or as thorough as they were. And in that response, a lot of contractors have not been as prepared for audits because they always thought it was the way it is. Now, so why are you doing all this? Because the OFCCP is being more aggressive. They are doing more audits. They're doing more thorough audits, and they're finding many more violations. Audits are a big deal, but you'll know you're having an audit. You might get a notice of scheduling letter, and then you may, and then you'll receive the scheduling letter. We've had clients where they get a notice of scheduling letter, and then 2 days later they get the scheduling letter. We've had clients that get the notice of scheduling letter, and then they get a scheduling letter 6 months down the road. There's really no telling when it's going to come, but what's really important, and if you've ever worked with other federal agencies, particularly the EEOC in an HR capacity, you know that there's a conversation that goes on, and they'll say, you know, we need an EEOC response to the charge in 20 days, and you call them up and negotiate, and you say we need a little more time. They say, okay, that's fine. The OFCCP doesn't operate that way. The 30-day countdown begins when you get that letter, and 30 days is 30 days. It is extremely rare that anyone gets an extension. There are plenty of war stories about the HR manager that's been on vacation for a week, comes back, doesn't see the letter for another week, finally sees it, calls us up and says, hey, you know, I found this came in 15 days ago, and our response is, well, we have 15 days to respond. The OFCCP is not going to look favorably and is not going to provide an extension. Only in the utmost, just most unique circumstances will they even consider it. And a lot of that is because they see this as your obligations are an annual obligation, so you should be doing this anyway. All right. Again, why are you doing this? You can face periodic reviews for up to a couple years where they come in, look at what you're doing, make sure you're doing it correctly. Back pay, requirement to hire folks, and you could lose your federal contracts or be debarred from future contracts. Just the other day, there was a $1.85 million conciliation agreement signed to settle it. The other part of this too, why are you doing this? Because if you have multiple sites, the OFCCP is coming in and trying to find reasons, not just to audit one site, but to find reasons to spread out to your other sites. It's a huge issue, and you need to be that's why we recommend that if you have an audit, you need to have representation, so you have someone that goes through this more frequently and knows the in and outs. So let's go through the takeaways really quickly. The OFCCP is more aggressive and more thorough than it used to be. There's more violations being found than in the past, particularly ones with higher $6 and $7 figure conciliation agreements or settlement agreements. And that if an applicant or employee information isn't captured when you have the opportunity, it's likely gone. But here's the upside to that. You've just sat through a webinar, and now you have a better understanding of what you need to be doing or what you could be doing better, or maybe confirmation that you've been doing a good job. And so understanding, planning, and maintaining these plans will help keep you in compliance. The worst thing in the world is to find out that you're not doing something when you get audited. So being ahead of the curve is going to be a really big deal. Make sure your ducks are in a row before the OFCCP talks about it. With that, we've completed the presentation. I want to thank all of you. We've got one more slide that has your information that you need, and I'll go ahead and progress to that. Want to thank you all. I'm not sure that we really have any time for questions, but if you send them in, then we'll get back to them and answer them. And also, if there's any topics that you'd like to hear more specifically about, let Eric or myself know. Eric's email is at the bottom, and my email is throughout the presentation. So let us know if there's a topic you'd like to hear more specifically about, and we'll see if we can maybe put a future webinar together on that. Likewise, keep your ears open for the paid sick leave and for paid sick leave changes and final ruling, as well as that fair pay and safe workplaces. For those of you that can stick around, we've got a few questions, and I'll see if I can work through those. going to scroll through them. So while you're writing that down, Eric, I think you might have a few things to clean up while I'm reading the questions.
Yeah, thanks, Michael. If you want to go ahead and read any questions, go ahead.
Sure.
I think you got to most of them. But yeah, I mean, you said it, the SHRM and HRCI codes are on the screen. So I'll just go ahead and let you read those questions if you've got them.
Yep, I'm scrolling through them right now. Let's see. I think
one thing is, everybody, we will send you the slides and a recording. I'm out of the office tomorrow, but I will get that out on Monday. So look for an email on Monday with the slides and recording.
Okay. One last question that came in is the minimum for those working on the site, and I believe this question is in reference to the minimum wage. There's questions. It is, if we're talking about minimum wage, the minimum wage is going to apply to people working on certain types of contracts, and so you're going to have to figure out which contract they're working on. It can also be broken down by the number of hours they're working. There's a lot of specifics that go into who and how much they have to be paid. I wish I could answer that a little more clearly, but feel free to reach out to me afterwards, and maybe we can work through some more specifics. Like anything in employment law, this is very, very fact dependent, and so I'm going to probably have to ask a lot of follow-up questions to try to figure out what maybe the answer is. Let me see. I think we've got one more question that might have come in. One of the questions was, how do we know which of the federal contractor posting requirements apply to us? The federal contractor requirements are attached primarily to the EO 11246. So if you qualify under that, then you're going to have those 3 postings that I showed you there. Again, those are on the OFCCP site. I should also mention, just as a caveat to be thorough, you may have other local rules that you have to post for state laws. There are maybe also other federal laws that require posting that I didn't cover here. Let's see. The pay transparency, there was another question about pay transparency, if you have to include it. There was a question about not necessarily knowing when the contract started. My response would be, whether you've entered a new contract, unless you know you're going to end being a contractor and your companies have decided, I'm no longer going to do this, it's a good practice to go ahead and put in your pay transparency language. This is for 2 reasons. 1, you may already be covered by it. 2, if you are already covered by it, you need it in there. And then 3, you're likely going to be covered by it in the near future, so you might as well go ahead and incorporate it into your handbooks. I do a lot of handbooks for clients, so if you need help with a handbook or figuring out which language to put into your handbook, again, I'm happy to help you with that. But yeah, I think that's one of those things that it's not going to hurt you if you're going to be covered under it, and it's the best practice to go ahead and start preparing for that. Same thing, and I'll go ahead and plug the 56 hours of paid sick leave. While we don't know exactly what that's going to look like, starting to work with your compensation manager, starting to work with your executives who are going to need to know about this. As you can tell, 56 hours of paid sick leave is a lot of time. It's something that's gotten a lot of pushback but doesn't appear to be going away. One good thing that you can caveat that, or that you can put out there too, is that it is explicit that you will not have to pay out employees for the accrued unused paid sick leave. Now, I have to say there may be local laws that require you to do so, but again, this is one of those things we're not entirely sure how the final rule is gonna look. Some people have projected that maybe the final rule will trump local laws and say, well, this is a federal issue, this is not a local issue. But again, until the final rules are set and done, we really don't know how it's going to be applied and how you're going to have to roll it out for your workforce. But it is something you want to consider and start thinking about now, so you're not hit by it hit by it unexpectedly in the future. With that, I don't see any more questions that have come in with the chat screen. If you've sent me emails to my personal email or to my work email, then I'll try to respond to those as quickly as possible. I don't have anything else, so I'll let Eric close up shop. But again, thank you all so much for giving me this opportunity to present to you, and hopefully we'll be able to do this again soon.
Yeah, thanks, Michael. Really appreciate you coming on. Like he said, a lot of this stuff could be a presentation in and of itself, and with the increased aggression of the OFCCP and their auditing, we're definitely open to putting on other events in the future. So if there's anything you want to see more of, definitely let us know by email. Michael, I would go ahead and ask you to flip over to the next slide so they have your email. Ask either of us. As I said, we'll send out a slide and recording of this webinar on Monday. Michael, do you have any other thoughts before we go?
No. Again, thank you all so much for the opportunity, and hopefully we'll do it again soon.
Great. Thank you, everybody, for coming out, and have a great day.